Can states secede? A few years ago, one of my favorite YouTubers tried to answer this question in the context of Texas. At that time, a petition on the White House website reached a threshold of signatures requesting Texas be allowed to secede from the United States. The White House gave their answer of no several months later, and Gray's video gave the same answer. As much as I respect CGP Gray, I am afraid he is wrong on this. He was right on the viability of certain states to successfully secede, but the legal question of secession is a bit more complicated. There is no written process for a state to secede in the Constitution, and the Supreme Court has ruled secession illegal. However, there are asterisks attached to both of those statements. The first asterisk is the lack of a formal written process for secession. The right of secession is not specifically mentioned, but similar to jury nullification in that it is a consequence of other laws. First, we look at the 10th Amendment of the U.S. Constitution. The powers not delegated to the United States by the Constitution, nor prohibited to it by the states, are reserved to the states respectively or to the people. What this means is that states can do anything as long as the Constitution doesn't say they can't. Secondly, we look at Article 1, Section 10, which lists everything states are not allowed to do, such as make treaties, coin money, grant titles of nobility, tax imports or exports, have a standing army in a time of peace, or engage in war. Side note, those last two have an asterisk saying that it's okay for them to do those things if the state is actually invaded or invasion is imminent. If you look at those, you will notice that secession is not there. And before you go on about how the word secession had not yet been coined, the idea already existed and would have been simple enough to add. With Article 1, Section 10 giving a specific list of things states cannot do, and the 10th Amendment giving states the right to do anything that is not explicitly forbidden, leaves a legal loophole allowing states to secede. This loophole was recognized by many politicians the last time states tried to secede, and some tried to get a constitutional amendment passed that made secession illegal. However, before this could be done, President Lincoln took matters into his own hands and invaded a place that was technically its own country, but not recognized. So technically means he was invading part of his own country, which technically means that the most deadly conflict in American history wasn't a war, except it was, and it only gets murkier from there. But what about the Supreme Court? The Supreme Court has ruled indirectly on secession twice. The first case was in 1869 in Texas v. White. The post-Civil War government of Texas wanted to reclaim some federal bonds that the Confederate Texas government sold off during the war. This new Texas government argued that secession was illegal and therefore all acts of the Confederate government of Texas were null, including the sale of the federal bonds owned by Texas. Unsurprisingly, the Supreme Court sided with the federally controlled government of Texas and declared unilateral secession unconstitutional. A second Supreme Court case in 1877, Williams v. Bruffy, also dealt with actions of a Confederate state government. In this case, the Supreme Court ruled that the legitimacy of a government's acts are dependent upon that government successfully existing, meaning that secession is only legal when they successfully secede. This is like saying that you only have the right to free speech if you can prevent someone from bashing in your head with a bat. This logic contains a kind of barbaric existential truth, but it shouldn't be the basis for civilized law. So, do the states have a right to secede? Technically, yes, but history has shown that the US federal government does not take too kindly to usurpations of its power. So if you're going to secede, you better play to win.